Good afternoon, and welcome to today's webinar, A Cross-Country Journey Through Emerging State Privacy Laws. My name is Josh Stevens. I'm an attorney with McMurray & Schuster. Before we get started, just a few quick housekeeping notes as we give people another minute or two to hop in here. Because this webinar is only 30 minutes, we will not be taking questions during the course of the webinar, where I will actually answer them at that time. But please send your questions. You can use the question box or the chat box, and then I'll follow up with you afterwards with responses to your questions. Secondly, you will get a link to a survey after the webinar concludes. It takes about a day for those emails to come out, and then the recording will also be available for later playback if you want to check that out. So with that, let's get going since we have a limited amount of time. As I mentioned, my name is Josh Stevens. I'm a partner here at McMurray & Schuster, where my practice focuses on privacy and telemarketing and other areas of compliance. And I'm just realizing how that white is reflecting off my pale face. We're going to get off these slides as quickly as possible. This presentation is intended to be a bit of an overview. It is an educational tool. It is not legal advice. Especially in this area of privacy compliance, small factual differences can make a huge impact. So before you act on anything you hear in today's presentation, definitely consult your counsel to make sure that it fits your situation. So during today's presentation, we're going to just do a quick little overview of kind of how privacy is playing out in the public consciousness at this time. We're going to talk about three key states here this year: Virginia, Washington, Oklahoma. You'll notice California is not on that list. That was the key state in 2020 and a couple years before that. So we are moving into some other states now. We'll take a broad look at the country as a whole, at other states, and then at the federal level. And that's where we'll wrap up today. So with that, as I mentioned, privacy and data security issues are top of mind. Just in the last few weeks, we have seen a number of serious data breaches that have affected government agencies, huge corporations. I'm here just outside of Cincinnati. Kroger is a huge company here in the area. It's headquartered here in Cincinnati. They experienced a situation with a data breach recently that exposed potentially some significant health data of certain consumers. These issues are really top of mind. And we've got a few statistics here that kind of demonstrate this from third-party sources. The first one here, right, 62% of Americans believe that it's not possible to go through daily life without a company collecting personal data about them. I'm actually shocked at how low that number is, just given, if you're using a television, if you use a phone, someone's collecting data about you at some point during the day. We are all shedding data about as much as we shed skin cells, right? So this is really a key issue for consumers. 79% of Americans are someone who are very concerned about the use of their personal data, and over 70% are taking measures to protect their online privacy. And we see this, and we see businesses responding to this. Google's announcement that they're transitioning away from allowing people to use third-party cookies in Chrome, Apple's new permissioning system related to using device identifiers, which has caused a huge hubbub in the marketing space, right? We are seeing businesses responding. We're also starting to see legislatures responding. And so with that, let's talk about Virginia, because Virginia just passed a new Data Protection Act. It was signed by the governor mere days ago. So I'm gonna compare and contrast it a little bit with California's CCPA and CPRA and the EU's GDPR, because I think that's the easiest way to handle that. What I will tell you is we're going to hit on just a few key issues with the Virginia law. We could probably do just a whole hour on that law itself, and in fact, we probably will over the course of the next few months. But just to get you at least some background on that Virginia law. So Virginia is the second state to enact a comprehensive privacy law, right following California. And while it is unique, it does borrow fairly heavily from both California's CCPA and CPRA regime and the European Union's GDPR. So the first question that always comes up is, does it apply to me? One of the nice things about the Virginia law is, unlike California's law, where if you were a business of a certain size, if you had 25 million a year in annual revenue, gross revenue globally, that law applied if you collected any information of California consumers. Virginia's bill is a little narrower. It's only going to be triggered if you collect the personal information of 100,000 or more Virginia consumers in a year, or 25,000 Virginia consumers, but you derive 50% of gross revenue from the sale of that consumer data. So this is going to help a lot of smaller businesses not have to deal with it, but 100,000 isn't really that high. If you're doing significant marketing, for example, into the state of Virginia, you're probably going to get 100,000 leads, right? Or you're going to buy data files that might have 100,000 Virginians' information, so you can send a mass mailer, or you can send an email campaign or something like that, right? It's not that hard to get over that threshold. Now, there are some key exemptions. There are, under the Virginia law, two sets that are structured around either entity type or the data type. So if you think back to CCPA, most of the exemptions in CCPA were based on data type. So if, for example, the data was governed by GLBA, then that data was exempt, but the business itself could potentially still come under the California law for data that was not subject to GLBA. Virginia's a little different. For Virginia, if you are a financial institution who's regulated under GLBA, you are completely exempt from the Virginia law, even if you have certain data in your files that is not regulated under GLBA. The other couple large entity type exemptions are HIPAA covered entities and business associates. Again, under California, that was a data-based exemption. Here, it really is a entity-based exemption, and nonprofits and higher education institutions as well. Then there are data-based exemptions. So for example, employer-related data. There's a similar exemption under CCPA, CPRA in California for information collected in that employer-employee context. Now that one, remember, is a partial exemption, and it is set to expire on January 1 of 2023. Here in Virginia, that type of exemption is actually permanent and is quite broad. Also, data that's governed by some other federal laws like FCRA, the Fair Credit Reporting Act, the Driver's Privacy Protection Act, or FERPA, the Family Education Rights and Privacy Act. Those types of data-based exemptions are in place as well. So just keep this in mind. Institution exemptions, get the whole institution out. Data-based exemptions, the institution might still be in, but certain types of data are out of coverage. The Virginia bill looks, again, very similar, as I mentioned, to California and to GDPR, right? You see the familiar rights to access, deletion, opt-out of sale, but the Virginia bill adds some more. So a right to correction of inaccurate information, the right to get a transfer of your personal information to a third party, and the right to opt out of targeted advertising. And this is going to be a theme you're going to hear. There's another state I want to mention that's got a similar kind of opt out of targeted advertising regime. Legislatures are getting wise to the fact that a lot of consumers find that type of data processing a little creepy. It's a powerful tool for businesses, but there's a growing number of consumers who just don't really care for it. And so they're trying to give consumers the ability to get themselves out of it. If you recall, under CCPA, before acting on a consumer right, you have to verify the consumer's identity. And there were two standards, reasonable degree of certainty and reasonably high degree of certainty, depending on the right that was being exercised. Under the Virginia bill, there's going to be just one standard, a commercially reasonable standard, which should make things easier for businesses, only having to apply one identity verification regime rather than two. One of the other key differences is consumers actually get a right to appeal a denial. So if, say, a consumer makes a deletion request and the business says, no, we're not going to delete this information, here's why, sorry, but we're not going to do it, the consumer actually gets the right to appeal that decision back to the business, and the business has 60 days in which to respond, and there are certain parameters around what that appeal process is supposed to look like. The Virginia bill also puts a number of obligations on controllers of personal information, right? So that the business that sets the purposes and means of the processing. One of the key ones here is that the collection of the data has to be limited to what's adequate, relevant, and reasonably necessary for the purposes that are disclosed to the consumer. So the days of just, well, I'm going to hoover up every little piece of data that I can get, and then I'll figure out, well, do I really need it? Why do I need it? How am I going to need it? Those days are coming to a close. Under the Virginia bill, you actually really have to engage in an analysis of, okay, here's what I want to do. Here's what I've disclosed to the consumer about how that I'm going to do it. Is my collection of data and processing of that data actually adequate, relevant, and necessary for those purposes? There's also tighter restriction around sensitive personal data. We also see this in CPRA in California, which comes into effect in 2023, that there are heightened protections for sensitive data. So you really need to look at your data sets against those definitions and see if any of the data you're collecting meet them. And we have disclosure requirements, right? So if you are going to be using data for targeted advertising or selling that data to a third party, there are heightened disclosure requirements under the Virginia bill that go above and beyond what the CCPA had. And lastly, on the controller responsibility section, what I want to point out is this concept of a data protection assessment. This is a concept that's borrowed from GDPR. It's now being brought into the US frameworks, where essentially the business has to do a risk assessment, looking at how their data processing impacts consumers and impacts people's privacy rights, and whether it's reasonably necessary or not, and what security measures are in place, and then figuring out how to reduce those risks, mitigate those risks, and really privacy by design has to be brought to the forefront. Data processor, so if you're on the processing side, you don't set the purposes and means, you've got a client who gives you data and says, you need to process this data for me. You're gonna need to have really great contract provisions that are very GDPR-like in terms of what data you're processing, how you're processing it, how long you're processing it, how are you storing it, what are the reasons for the processing. So really detailed agreements now. And one of the keys of that agreement under the Virginia law is the processor has to assist the controller with fulfilling their responsibilities under the law. Now, I've probably terrified you with all these things that you've got to do, and you're sitting here thinking, oh gosh, I mean, I've got 2 years to work up a plan to make this happen, but what if I mess something up? Well, this is where the Virginia bill is actually kind of nice. So it's enforced by the Virginia AG, but it has a notice and right to cure provision. So before the AG can take action against a business, they have to provide notice of the violation and give the business 30 days to cure it. If the business doesn't cure it within that 30-day window, then the AG can seek enforcement for up to $7,500 per violation, plus the state's expenses and fees. Now that $7,500 is for intentional violations. There's a lower $2,500 per violation threshold for unintentional violations. But what I always like to remind people is that when we think about violation, that's an easy term to start multiplying, right? So if you've collected 100,000 consumers' data and they all have the same potential problem, that's 100,000 times that 7,500, right? It can add up quickly. Thankfully, no private right of action under the Virginia bill. So it's pure regulatory enforcement. That should give more flexibility for businesses to be able to work through issues as they come along. So let's look at 2 bills that are on their way to passage, but haven't quite crossed the finish line yet. First is from Washington State. This is Senate Bill 5062. It has passed the state Senate. It's currently pending in the state House. If you recall from last year, Washington almost passed their Privacy Act. It passed both chambers. It was in conference committee, and then they literally just ran out of time. Their state constitution only allowed the legislature to be in session so many days in the year, and it just ran out. So we suspect this bill will pass this year. What we're hearing is that the two houses worked out their differences over the course of what was left of 2020. And so we fully expect this will pass. If it does, has effective date of July 31st, 2022. So not quite 2 years. In fact, by the time it passes, you might really only have maybe 1 year to get into compliance. It's again very similar to California. It uses a lot of GDPR terminology, though. You can definitely see the GDPR influence on this bill. One of the things that I want to really highlight from this one is the consent for processing sensitive information. So again, this concept of two different types of personal information, kind of general personal information and sensitive personal information. Under the Washington bill, before you can process that sensitive personal information, you got to get consent. This is somewhat similar to GDPR. GDPR has a few exemptions to that general rule, but that concept is flowing through here. And then again with the concept of the data protection assessment. Now here in the Washington bill, they give us some things that trigger when you have to do that. If you sell people's data, if you profile people or engage in automated decision making, if you're using targeted ads, or if you're processing the data and it's of a sensitive nature, right? One other thing I'll say about sensitive, a lot of people don't think, there are certain things that come under the sensitive label that are not inherently intuitive. I think everybody thinks when they hear sensitive, like, okay, medical records, detailed financial records, maybe driver's license, social security number, things like that. These definitions often also include race, ethnicity, sexual orientation, sometimes gender, religion, philosophical beliefs, or union membership, or political beliefs sometimes as well. So these sort of demographic elements that we often would not think of as sensitive can sometimes be, depending on the way the definition's worded. So it's definitely something you're going to have to pay close attention to, because it's going to vary from state to state to state as to what is sensitive. Consumers have, as I mentioned, this bill looks very similar to CCPA, so a lot of the same types of rights. In fact, the same types of timeframes in terms of processing, how quickly those rights requests come in, how quickly you have to turn them around. Like with Virginia, there is an appeal process under the Washington law. So you have to give consumers the right to make some appeals. And you have 30 days in which to handle that. Also, like the Virginia law, there is an obligation, if you're a processor, to help your controller comply with the law. So if you are a traditional service provider, say you're a contact center who handles calls for a client, that client is the controller, you're the processor of that data. These laws are really putting obligations on you now to help those businesses comply. And we have seen, at least in our practice, controllers are starting to put those obligations on processors through contract. So your clients are likely to be coming to you and saying, hey, in order for us to comply with the law, there are certain things we've got to put in our contracts now. But just keep in mind that you as the processor, you can push back on some of those, and there has to be that give and take, that negotiation that happens between the two as to who takes on what responsibilities, how far the processor is going to go to assist, who bears the cost of that assistance, right? Can the processor upcharge the client, or does the client say, no, processor, I just think you need to eat this cost, right? Those negotiations are going to happen, and they're going to happen on a one-to-one basis. We're seeing that this is a huge lift for clients with just the California law. And then with CCPA, We're now going through this again with CPRA because it modified those requirements. Now we're going to be having those negotiations again for clients with regard to Virginia. So this is a process that's going to just kind of keep happening over time. And so you as a business, whether you're a controller or a processor, are going to have to really think through a business plan for how do we handle these contracts. Because I will tell you, we're seeing that's probably one of the biggest lifts for clients. And then, like the Virginia bill, the Washington bill does not have a private right of action. It's regulatorily enforced. However, Washington has this General Consumer Protection Act that does give consumers a private right of action in certain circumstances. The way the Washington bill is currently written, it says that that bill cannot be the basis of a private right of action. But it then has a sentence later that says that the bill is not intended to essentially curb any rights that the consumer would have under any other statute. After CCPA was passed, we did see some lawsuits where consumers tried to essentially shoehorn a CCPA claim into a general consumer protection claim under California's General Consumer Protection Statute, essentially saying that certain things were a deceptive act. You know, you used my data in a certain way that you didn't disclose to me. That was deceptive. I'm going to sue under this other law. It's going to be interesting to see if a similar attempt occurs under the Washington law when consumers realize and consumer attorneys realize that there is this provision that says it's not intended to curb anything that is a right provided any other under any other statute. So we'll see what happens there. I will tell you those cases in California have not gone very far, but every state is different. Now here's the one that I think has been a bit of a sleeper and has snuck up and we really need to pay attention to, and this is the Oklahoma bill. And you're probably thinking, Oklahoma, what are they doing passing the privacy bill? This does not seem like them. Yeah, I mean, this was not a state that we expected to see one come out of, but here it is, and it's HB 1602. It has already passed the State House 85 to 11. It was overwhelmingly passed. It's now pending in the Senate. If this bill passes, it has a very quick effective date of November 1st this year. Like the CCPA, businesses can be pulled into this one based on their gross annual revenue. And in fact, the threshold for the Oklahoma bill is only 10 million. So it's lower than the California bill. And somewhat terrifyingly, the Oklahoma bill includes a private right of action with statutory damages. So while enforcement can be done by the state through the Corporation Commission with civil penalties up to $7,500 per intentional violation, $2,500 per unintentional, there is a private right of action, and the statutory damages are the same thresholds: $2,500 for unintentional, $7,500 for intentional. And if any of you are familiar with the telemarketing world, with TCPA and the private right of action under that law, there's going to be a market, right, for these claims. And what really gives me pause with a privacy claim as opposed to a TCPA claim is there's a lot of gray, right? In any privacy thing, you are making judgments about what is reasonable, what is adequate, how does something have to be written to explain it to a consumer. They're imprecise things. And so a private right of action would seem to open the door to significant private enforcement. Another thing with the Oklahoma bill is it's an opt-in regime. There are a number of legislative findings in the bill about how opt-out regimes don't protect consumers. They need to be opt-in. And so one of the opt-in mechanisms is for the sale of data. And I'm just going to read you real quickly from the bill the notice that has to be given to the consumer. So before you can sell a consumer's data, you have to give them a notice and get their opt-in. Here's what the notice must contain: the information that may be sold, the persons to whom the information will or could be sold, the pro rata value of the consumer's personal information that is being sold, and that the consumer has the right to opt in. And they also have the right to opt out. So to provide this detailed notice and then get the consumer's consent. Likewise, there's a provision in here that has notice requirements around just the basic collection of personal data and requires the consumer's consent before you can collect even basic data. So, and even not for sale, just to collect it. So this bill's got a lot of really onerous provisions. We'll see what happens with it. As I mentioned, it passed the State House with a wide margin. We'll see what happens in the Senate. But this is definitely one to keep an eye on. And those states aren't alone. As I mentioned, there are bills pending coast to coast. Here on this map, your sort of middle blue are states where there are bills that have been introduced but haven't passed a single house of the state legislature yet. New York has 4 bills on its own. We are watching this. In fact, we offer clients, and if any of you are interested in this, feel free to reach out. But we offer clients a legislative monitoring service where we track and follow these bills and provide updates on them and background on them, because you really do have to watch these. Again, this is starting to look a little bit like how telemarketing is regulated in the US, where we have a patchwork of 50, 51, if you include DC, frameworks that you have to deal with, and it seems we're heading down that path. So what's happening at the federal level, right? People want to know, is the federal government going to come in and solve this problem? I don't think so, and this is just my opinion, but the Democratic majorities in the House and the Senate in prior years when they considered privacy legislation were always against preemption. No matter what the bill had in it, they wanted the state laws to remain in place. If you don't have preemption, then you can have a federal framework, but you still have those 51 state plus DC frameworks that are built on top of it. So wherever there are gaps or there are differences, you have to manage those. I think there is the political will for a privacy bill. We know that Kamala Harris has felt very strongly about privacy for a long time. Consumers are clamoring for privacy regulations. We have seen the New York Times had an editorial pushing for federal privacy regulation. But again, without preemption, all you're doing is adding another layer. And while that's great for consumers to always have this floor in America that a state can't go below, from the business perspective, it's very challenging. It keeps people like me employed, but it's very challenging to manage all of those different frameworks. So, what can you do as you're thinking through your privacy regimes within your business? Privacy has to become a priority. It has to have investment. And I know for a lot of businesses, it's often an afterthought, but what we're seeing percolating up here from the States, you're gonna have to really invest in it. And you're gonna have to have privacy by design. We're seeing these data protection impact assessment requirements now, right? So you really are gonna have to think about, before you take a step, what's the impact of that step through some formal process, right? And then you're going to have to figure out, in terms of consumer rights, how are you going to handle this? Are you going to maybe have a internal process that meets the requirements of every state? And if a consumer in a state doesn't have rights under the state law, well, they get the rights because it's just operationally easier if we just give them to everybody. Or are you really going to try to manage state by state by state by state in as tight a way as possible? Those are the big decisions that you have to make. And unfortunately, we're quickly rolling up here. 2023 will be here before we know it with Virginia and CPRA. And then if Washington and Oklahoma pass, we're going to be facing those laws even faster. So If you didn't go through that process with CCPA, you really need to start thinking through that process. If you did go through that process with CCPA, you've got to start thinking about how these laws will play with what you've already done under CCPA. So with that, I hope I've given you a little bit of food for thought this afternoon and didn't terrify you too badly. If you have any questions after the webinar, please do feel free to reach out. And just a quick plug, our next Thirsty for Knowledge Thursday webinar will be April 15th, also at 1 p.m. Eastern, with a litigation focus. I'm hearing that it may be related to class actions and important developments that are happening in the class action space. And with that, thank you for your time today, and we'll talk to you soon.